Hello, everyone. Thank you for joining in. Uh, we will be starting the webinar in about 3 minutes. Webinar starts at 12 p.m. Eastern Time. So thank you for tuning in early. We will begin the sessions shortly. Thank you. Prashanti has joined us for today's session. We'll get underway in less than 2 minutes. Thank you. All right, it's 12 o'clock. We can get started with today's all important session. It's an urgent webinar. We've prepared this considering the circumstances surrounding us. Today, I'm joined alongside Prashanti Reddy. My name is Vishal Sharma, and I'm your moderator for today's session. Um, Prashanti is an award winning immigration attorney specializing in immigration law with over 25 years of experience. She's an esteemed member of the American Immigration Lawyers Association and the New York Bar Association. And she's also currently admitted to the bar in New York. Prashanti is actively involved in the position of an advisor slash immigration counsel for Indian consulate in New York and is actively involved in pro bono legal work alongside everything else. Prashanti is, as she has been in the industry for well over a couple of decades, there's a whole list of achievements and recognitions. The most recent being listed by Forbes as one of New York City's best immigration lawyers in 2024. On that note, we can have the session underway. Prashanti, over to you.
Thank you, Vishal, for that introduction. And hello, everyone. And thank you for joining us at such short notice. This is kind of an emergency webinar because it's the need of the hour. There have been so many things happening, and we simply have to get it out there. And there's still so much confusion around, the H-1B proclamation and also the changes or proposed changes to the H-1B lottery. And we also have some good news with reference to the October Visa Bulletin. So some pointers on filing your 485. We will talk about that as well. So it's a mix of good and not so good news. But we're still waiting to see to what extent these laws are actually enforced and what happens in the courts, and if the administration will backtrack Will they revise it in some way? We have to wait and see. But let's look at what the law is, or the proclamation is, as of today. So please keep in mind, as I said, it's not an executive order, it's a proclamation. There was an executive order as well. It was about the gold card. And that, I guess, could be thought of as good news, but we'll discuss that later because the gold card could have some implications with reference to EB5, and it could take away some, much needed green card numbers. The green card numbers, as you know, visa numbers are already oversubscribed. And by introducing a new a new way of getting a green card, more of the green card numbers will have to be taken away because they're not increasing the number of green card numbers, and they'll be taken away from the EB1, EB2, and EB3 and EB5 categories. So that's the bad news. But so let's talk about first the H-1B proclamation on 19th, on Friday. The White House issued a proclamation restricting the entry of certain H-1B non-immigrants, and it took effect on Sunday, on September 21. And it will remain in effect for 12 months, but they are supposed to revisit it just after the lottery, which is in March, 30 days after the lottery. So they want to revisit just before the lottery season. And it's basically affecting cap exempt employees, so those people that will apply under the lottery. So under this proclamation, US employers seeking to bring in new H-1B workers from outside the country must now pay $100,000 fee per petition. Now there's a controversy as to whether this is 100,000 a one-time fee. The Commerce Secretary said it was every year, and then they backtracked saying it was not every year, it's just a one-time fee. So the whole thing is a mess because there's a lot of information that is contradictory, and there are more questions than there are answers. And each time the USCIS or the White House is putting out information about the proclamation, it's just more confusing because more questions. They're not doing a good job of even the explanation of what the proclamation means. And every time they send out an explanation, there's actually more questions than answers. But as to what we know, without proof of this 100,000 payment, the Department of Homeland Security, the State Department will deny petitions and refuse entry. There are exceptions carved out in this proclamation. That is, people who work in certain high-skilled people, certain people that it is within the national interest of the United States to allow them into the country, and those who don't pose a threat to U.S. Secretary of Welfare, they will be granted H-1B even without the 100,000. So it remains as to who will be a NIW and who will get a national interest waiver. What is the criteria for a NIW in this situation, and how should it be filed? What is the fee? We're waiting for all that to come out. I suspect it'll be similar to a NIW that we filed for a green card, but they may carve out certain exceptions. I'm hoping for cutting edge technology fields, for AI, maybe for people who have done research in that area, maybe for healthcare professionals, doctors, nurses, especially working in rural areas. They might make an exception for them. But just to go to the basis for the proclamation, the basis in the law for the proclamation is 214F and 215A of the Immigration and Nationality Act. 214F is pretty much a travel ban, and 215A is used during emergencies. Actually, both are supposed to be used for emergencies. 215A is used generally during wartime, and 212F is used for health issues, usually if there's a health emergency, etc. And this was used in 2017 by Trump and his previous administration. for a Muslim ban, and it's important to know that the travel ban, though, was struck down by the lower courts. The Supreme Court finally upheld it, so we have a precedent for the travel ban, which now, so it's going to be difficult for the lower courts to uh, kind of say that it is null and void or unconstitutional. But because there's a wage factor to it, a fee factor, it's possible that we might be able to, challenge it in court. But 212F, as I said, was used uh, during the Muslim ban, and then again, so in 2017, and then again in 2020 during COVID. And then 2020 was removed in 2021 when the Biden administration came in, and COVID was no longer a danger. Um, it was removed then. So it's been used twice, the travel ban. Of course, the White House or the administration says that it is important because they argue that H-1Bs are affecting American jobs, they're depressing wages, and they say that it will protect US workers by reducing competition from so-called low-cost labor. I mean, of course, the critics won, and which is what I think also. It'll hurt innovation, and of course, it'll hurt business growth, especially in industries that rely heavily on it, such as I said, tech and healthcare as well. There's already a shortage of healthcare workers, so that'll definitely affect the industry. And as I said, legal challenges. We're waiting to see what legal challenges will be forthcoming. I don't see that there'll be a temporary restraining order because it's not something that will affect anyone immediately. Maybe a few people, but not a whole lot of people will be affected immediately. Most of them will be affected during cap season, which is next year. Next slide. So let's look at a few key provisions of the proclamation. The effective date was Sunday, September 21, and it's only for 12 months, so it's set to expire in September 2026, which is the beginning of cap season. Or you could argue the end of cap season, depending on how they actually enforce the 100,000. If they enforce it at the consulate and the Department of State, only at the time of entry because it's a travel restriction, then it's really not going to affect anyone because by then the proclamation may sunset unless it is renewed. But if they're going to enforce it, if USCIS is going to say that we're going to enforce it when you file the H1 and the fee has to be paid by outside the country, but we'll actually enforce it. We'll look for a receipt of the fee payment before you even file the H1, then it's going to affect next year's cap for sure. The scope is, it applies to H1 workers currently outside the United States. And again, there is controversy about this because different documents, there are about 10 different documents and each document says something different. But based on what I know and based on common sense, and we will wait to hear otherwise, but based on how I interpret the law, it is only for people who are outside the country. And it requires you to pay 100,000 before you can re-enter. It does not impact people who currently have a H1 approved or who are currently going for visas. It doesn't affect them also because the H1B, if it's already approved as of Sunday or before Sunday, then it doesn't affect them. Or even if it was filed before that date, it shouldn't affect them. So people who filed in the last cap and are coming to the US now for visas, applying for visas, it shouldn't affect them. Also, people who have traveled for business or who've traveled for pleasure and are coming back, already have a visa or applying for a new visa, it shouldn't affect them either. So petitions, USCIS is saying they will not process H-1B petitions for people working outside unless there's proof of payment. So if they continue with that, then it'll affect all the cap cases. There's some exemptions, of course, people who are in the US, so extensions of stay, transfers, so change of employers, amendments, also change of status applications, cap cases, where even though they've never been on a H1 before, they're new H1s, but they're not outside the country. Since this is a travel ban based on 214F, it should not affect those people who are presently in the country and filing for a change of status from F1 to a H1, unless they say otherwise, and they could. But as of now, based on the information we have, it doesn't affect change of status applications. But they've put in the proclamations that doesn't mean that you can come on a B2 and circumvent the 100,000 that way by filing a change of status to a H1, because they're going to look at that as a fraud petition. So something to keep in mind. So a further review, as I said, would be 30 days, within 30 days of the next lottery, that is within in the month of March 2026, there will be a review, and the Secretary of State and the Attorney General will recommend whether the restriction should be extended or not. So that's something to look for, to see whether it's extended beyond 12 months. Next slide. Some additional measures, as I was saying, the misuse of the B visa, the potential misuse, because they're thinking about that already. Also, the proclamation talks about revising prevailing wages and prioritizing admission of high-skilled paid workers. We haven't seen them yet revising the prevailing wage, but we might see that in the near future. But we've already seen that they are going to be publishing a new rule with reference to the lottery system. They're going to change the system from a pure lottery to prioritizing higher waged workers, and we'll talk about that a little later. And as I said, there may be exceptions. There are exceptions carved into the proclamation, and we have to see how those exceptions work. It could be by industry, by company, by individual. We'll have to wait and see. What is the practical consideration of this proclamation? I would suggest that whoever hasn't done so, file their petitions immediately before those wages are amended and become higher and maybe unreachable. File for your extension, file for your amendment. If you plan to change employers, file that transfer now. If your extension is due within 6 months, file it now. Don't wait for the 6 months. Same with amendments. Those who are planning to travel should do so immediately before there is some change in the law. And it's safest not to travel until we know more about what's happening. Next slide. This is a good way to segue into the lottery rule change that I was just talking about. So now it's going to be a wage-based system, and it's going to replace the random lottery with a weighted system based on the salary offered for the position. So the number of lottery entries an application will receive will depend on the wage that they're being offered. So higher the wage, the more entries they'll have. So for example, if you're level 4, you'll get 4 entries into the lottery system. So your chances are 4 times more of getting picked into the lottery. If you're level 3, you'll get 3 entries into the lottery. 2 is 2 entries, and level 1 is 1 entry. So the chance of getting picked in level 1 is like maybe 10%, while maybe level 4 will be much, much higher. So this is an issue for your change of status applications, F1 to H1, since they're usually level 1 or level 2. It's not, they are entry level people, so they're usually not level 4. So, and employers cannot afford to pay level 4 for them. They will be affected by the lottery. They are unlikely to get picked. But however, weighing against this is the fact that since there will be no cases filed under the cap for people coming from outside the country, maybe there'll be no lottery at all, in which case, it may not matter then, the wage-based system. So let's wait and see what happens. The proposed rule is currently undergoing a review process, and it's being submitted to OMB, the Office of Management and Budget. And after that, it will be published, and there'll be a public comment period for 30 days. And I think we are in that actually public comment period. And then the final rule will be developed based on those comments and based on the review by DHS. We do anticipate legal challenges to both the proclamation and the wage-based rule. The wage-based rule because as per Immigration and Nationality Act, it is first in. So whoever files their case first gets selected for the H-1B cap, and it is not based on anything else. So on that basis, I think we will see challenges, legal challenges. Let's wait and see what happens. But I must say the wage system is extremely unfair because not only are you forcing employers to pay level 4, but also it's unfair because geographically, if you were, say, in some small town in Utah, your level 4 salary is much less compared to, San Francisco level 4. So everybody will then move to the small towns and live there and work remotely so that they can pay lower wages and they can pay level 4 wages and get picked in the lottery. And that doesn't make any sense to me. So let's wait and see what happens with this rule. Next slide.
I would just like to remind everyone we are already seeing a lot of questions coming in, and we understand a topic like this and a timing like this, there will be lots of questions. So please feel free to drop in your question directly on stream or any of the other socials that you're streaming this session today. Prashanti will be picking up all the questions by the end of the presentation, and we will make sure that we do respond to your questions. The only request is please keep your question to one single chat so that we are able to get back to you easily. Thank you.
So let's go to the next screen now. And we'll talk about the October Visa Bulletin. This is a piece of good news amongst all the rest of the news that we have. The October Visa Bulletin, we've seen significant forward movement for employment-based as well as family-based, including for India. So that's great news. This is the final action date table that you can look at. Of course, there's much more forward movement in the dates for filing table for both employment and family. And USCIS has said they're going to look at the dates for filing table. But there is significant forward movement in the final action date as well. Next slide. So dates for filing, you see F2A, which is spouses and children of permanent residents. You see that's moved to September 2025. So it's almost it's current really, which is great news for September 22, 2025. Great news for India, Mexico, Philippines, China, and all other countries. So that's good news. Next slide. This is the final action date table, employment-based cases. And we see not as significant as dates for filing, but we do see forward movement by 3 months or so for both EB2, EB3 India. Next slide. Can we have the next slide? Thanks. Let's now look into the dates for filing actual movement that took place for employment-based category. I told you for family-based, the F2A really moved ahead for dates for filing. And why is dates for filing important? If you've never filed a green card, and if USCIS is looking at dates for filing, this is important. Usually the dates are far advanced than final action date, and this allows you to file in advance of your priority date actually becoming available. So this allows you to file a 485 and get the benefits of a 485, such as easy movement between employers, not having to depend on H1, access to EAD, so you're working for any employer as long as you do an AC-21, and advanced parole, so not having to go for a visa because you can travel on advanced parole. So let's look at it. For EB1, China, we see advancements of 4.5 months. It's moved to May 15, 2023. India advanced by a whole year. It's moved from 2022 to April 2023. All of the countries, EB1 has been current and continues to be current. EB2 also we see a forward movement for India of 10 months, China 11 months, and all other countries under EB2 visa category, including Mexico and Philippines, it's moved by 8 months to July 2024. Next slide. EB3 also we see significant forward movement, little over a year for China, 12 months, 14 months for India, and it's now in August 15, 2014. All other countries advanced by 2 months, and it's now in 2023 July. Next. Final action date, as I said, the final action date is actual priority dates availability, and this is important for you also because if you've already filed your 485 and you're waiting for your dates to become current so that you can actually get a green card, then these are the dates that you need to look at. And we see again F1, all other countries moved by 3 months, Mexico 7 months, Philippines 6 months, F2A, that is spouses and children of permanent residents, all other areas moved significantly, 1 year or 5 months, almost 1.5 years, Mexico 1 year, Philippines 1.5 years. F2B, unmarried sons and daughters, 1 month. All other countries, 8 months Mexico and 5 months Philippines. So you see there's forward movement in the final action date table as well. Overall, good news. Next slide. F3, married sons and daughters of US citizens. Not much for all other countries, 1 month. Mexico, 2 months. Philippines, 4 months. Brothers and sisters of US citizens, F4 is always backlogged and it continues to be backlogged. There's only a small movement of 7 days for all other countries. No change for India. China is 7 days. Mexico, 24 days. Philippines, 2 months and 21 days. So not much forward movement. For final action dates for employment-based, it remains current for all other countries. There's a slight forward movement by 1 month for China, no forward movement for India, no change in Mexico and Philippines. This is for final action date table for EB1. Next slide, please. EB2, slight forward movement, as you see, 3 months, China 17 days, India 3 months, Mexico 3 months. So slight forward movement in EB2, which is surprising because there hasn't been any forward movement in EB2 last year. So it's any forward movement is good, and we've seen EB2 moved significantly by 1 year for India for dates for filing, so that's good. EB3, again, small forward movement, 3 months and 3 months for India and China, 1 month for Philippines. EB4 is not available. EB5 for final action date, no change. India moved significantly by 1 year and 2 months. This is for unreserved category, that is the open category. That is people who are not in underserved areas. Next slide. What are the key takeaways? We've already seen that. Good forward movement in family as well as employment based. 1 year, 5 months jump in F2A and 14 months jump in EB3 India. These are significant forward movements. EB1 forward movement is there as well. So many people have become eligible for filing of a 485 because of these October dates. What predictions, if any, for the new fiscal year of 2026, since the new fiscal year starts with October? We'll continue to see some modest forward movement, I think, in EB1 and EB3. EB2 will continue to be backlogged. And I think any carryover from other categories and rest of the world, I think EB2 will get the benefit of that since that is the most backlogged category. Next slide. And talking more about 485s, since many of you may be ready to file your case, and if not, you should be already preparing your documents because the filing starts in October. You can file from October 1st. So you should have already gotten your medicals done. Let's see some filing tips. File in October. Don't wait until November because you don't know the dates may retrogress in November, or they may not use the dates for filing table anymore and you may not qualify then based on the final action date. Two of these things, any of these things might occur. So please file your 485 in October. Don't wait until November. And now even so, it becomes very important because H-1Bs have become so unpredictable. If your date is current, please don't wait to file your application ASAP. You have to file with medical, so that's why you need to start your process now because medicals might take 1 to 2 weeks. You cannot file without medicals. If you file without medicals, the case will come back and you will not be able to resubmit on time. Birth certificates, don't wait for birth certificates if you don't have them. And if you don't have the non-availability, it's fine. Just you'll get an RFE and then you can deal with it then. File though with birth affidavits and other secondary evidence that you have. It's easy enough to get a birth affidavit from people who were present at the time of your birth. That has to be notarized. And any other secondary evidence that you might have, such as a school certificate, a school leaving certificate, or maybe you have a letter from your priest, or maybe you have a letter from the hospital, whatever you have, submitted. If you don't qualify because you're an EB2, you should have filed an EB3 because whoever qualifies for EB2 qualifies for EB3 as well. So you should have an I-140 for both EB2 and EB3 so that you can take advantage of the situation. And don't file an amendment, file a new I-140 application for EB3. But if you haven't done it, you can do it now. File an EB3 application and file a 485 concurrently. Do both and take advantage of the EB3 dates because they have moved by 14 months. And there's a huge difference, 8-month difference between EB2 and EB3. If you have both EB2 and EB3, then obviously you don't have to refile. You can just file your 485 and file a 485J and ask for transfer of underlying status so that they look at, the EB3 if that's how you qualify. You don't have to file transfer. They are supposed to look at the most current I-140, the I-140 that is most favorable, but sometimes they don't, so it's a good idea to file that 485J. Just a reminder, EB1, extraordinary ability, you don't have to file a 485J because there's no employer involved. You're self-petitioning. Please file your EAD and advance parole along with your 485. Firstly, if you're on a H4, it offers much more flexibility because you have automatic extensions for a H4. If the H4 is expiring, then there is no automatic extension on a H4 EAD. So don't think that I have a H4 EAD, it's the same, I don't need to file a 485 EAD. File it. Whether you use it or not, file it and keep it. Same with if you're on a H1, you've seen what's happening with H1s. It's always better to be on a APEAD status rather than being on a H1. There's many advantages to that. And last but not the least, if your 485 is taking a long time to process, and if your visa number is available, and then you're not hearing anything from USCIS, litigation is an option. You can file a mandamus petition in court asking USCIS to process and give decision on your case. Next slide. Who is eligible for adjustment of status? Again, very important. You should have been inspected in the US. You must properly file for a 485 adjustment of status application. You must be physically present in the US. You cannot file if you're not in the US. You have to file consular processing then. You must be eligible to receive an immigrant visa. An immigrant visa must actually be available to you when filing and also at the time of adjudication. So it has to continue to be available. And only then your case will be adjudicated. Otherwise, it'll just remain pending. Must be admissible, so there should not be any grounds of inadmissibility that, such as, if you have a criminal case against you, then you have to file a waiver if you and get it approved before you're able to file a green card. And of course, there is a merit of favorable discretion. It is up to the USCIS officer whether to give you a 485 or not. Overall, it's based on discretion. It's something that we often forget, but please remember that. Next slide. What documents are needed? And we're reaching the end of the presentation, so please have those questions ready and we'll get into the Q&A as soon as we finish. What documents are needed for a 485? Again, important. We did talk about some important documents that were needed. You also need 2 passport size photographs. The photographs have to be white background, facing front, and there are instructions on the photographs, and you have to follow those instructions. Otherwise, sometimes even the case might come back and then you might lose the opportunity to file. Government issued ID, birth certificate, we discussed that, non-availability certificate if you don't have a birth certificate, inspection and admission or inspection and parole documents, so the I-94 if you've been inspected. Proof of your status, you have to be in status in order to file a 485 then. So I-797 approval, a H1 approval, most probably if you're on a H1 or a H4, whatever your status is. Medicals we talked about. Make sure the medical exam is not only are you submitting it, but it has to be complete. It cannot be partial. Again, the case will come back if it's partial. So make sure you get a copy of your medical, because you're not allowed to open the sealed envelope, but the doctor's office can give you a copy. And you make sure that it's signed and make sure it's completely filled out. Otherwise, go back to your doctor's office if you have any questions about it. If you have ever been involved in any crime, nowadays even petty offenses, criminal traffic violations, criminal violations are also flagged. So if you have any such issues, then you would submit all your court records, certified copies of your convictions, etc. And maybe get a waiver ready. You might qualify for a petty offense exception if it is a misdemeanor. And with that, next slide, I think we're done. Yep, so we can open the session to questions.
Yes. So I'll pull up questions in the order we've received them. And for those who are streaming us from any of the platforms, whether it is Facebook, LinkedIn, or YouTube, you do have the ability to drop in your question and we'd be happy to answer them now. Prashanti, the first question we have is from Keyur Pandya. Wonder who falls within a definition of new petition for H-1B. Would it be just those who never had any H-1B in past, or also those who have had H-1B in brackets approved I-140 bracket close and currently outside USA while getting another different employer to file H-1B transfer for them.
So this is a question that is not yet has not. I mean, if you look at the proclamation and you look at the comments on the proclamation and the USCIS memo after that, there's very little information available. We don't know whether that is intentional, they intend to be vague, or whether they're trying to figure out who qualifies and who doesn't. They don't. They just you know did this too quickly and did not actually think through who qualifies or who is under who under the proclamation who qualifies or who doesn't, right, for the 100,000 wage. But just looking at everything that they've said and kind of reading between the lines, I think they meant this for any person who is, number one, outside the country, and number two, a person who's uh, filing a new petition. But also, there is some language in the proclamation which says that a person who's never uh, had a valid H-1B petition before. So I'm wondering whether this particular scenario, whether it will be subject to the proclamation or it won't. As of now, I think that it is subject to the proclamation, and we have to wait and see if they explicitly, say that these kind of cases are not. And another case would be where a person filed a H1 extension after Sunday, so anytime uh, this week or later, and if they're going outside the country for a visa, then are they subject to the proclamation? That's another question that I would be interested in getting a response to. And again, if we look at the proclamation and we look at that particular part where it says only people who've never been on a H1 before, only they are subject to it, like people who are cap subject, then all these cases should not be subject to the 100,000 fine. So we're waiting to see, get more information on it. And many organizations have filed FOIA requests under the Freedom of Information Act. And I don't know, I don't think they've actually figured it out yet. So even a FOIA request, I think we'll have to wait. And even people are waiting even for litigation because they want to figure out who is affected and who is not before they litigate. So we're waiting to see. We should know very soon. But um, I think that it shouldn't be, but let's wait and see.
Okay, I'll go to the next one. This is from Ankita Gupta. What does it mean that it will remain in effect for 12 months? What happens after 12 months?
Well, after 12 months, the travel ban may not remain in effect. The travel ban is meant to be temporary. There was a Muslim ban, as I said, in 2017. Then there was COVID ban in 2020. There were all travel bans, uh, and they don't exist anymore. So this travel ban could either exist for the duration of the administration, which is administration, or it could uh, become null and void in September of 2026. They are going to wait and see. They're going to revisit it as early as of March of 2026 to see if they want to extend the travel ban.
All right. I hope that answers. Go to the next one. This is from Anand Makate. Any clarity on the case H-1B stamping in 2025 April, never travel to US? Can we transfer to new employer? Will it be impacted by the fee?
Yeah, good question, because you're actually now filing a H1B, a new H1B even though it's cap exempt. So the question is if cap exempt H-1Bs are going to, whether the fee will be applicable to them or not. And that was the similar question that Kayur Pandya had asked earlier. So we are waiting to see. But as of now, I think all petitions where people are outside the country and they're filing a H1 after September 2021, after September 21st, 2025, will be subject to the $100,000 fine. Let's wait and see if it's otherwise.
All right.
Especially also, I think, just going back to the previous question of Ireland, especially because you're traveling, you're going to get a new visa now. If you already have a visa stamping, then you're only going to the port of entry. But if you were traveling with the same H-1B, it wouldn't have been an issue. But if you're filing a new H-1, I think you might be subject to the proclamation.
Okay. Moving to the next question from Rajnikant Punjala. Will this new WB rule and 100K remain, or companies will fight battle and get relief?
I think already there are some organizations that are looking for plaintiffs. I believe the South Asian American Justice Collaborative, in coalition with Impact and the Justice Action Center and Democracy Forward, all these organizations have joined together and they're seeking plaintiffs to challenge the executive order, this executive proclamation. And they have given information as to who to contact if people want to be part of that lawsuit. And they're basically looking for individuals or employers who plan to file a H-1B cap. So you might not see temporary restraining orders because it doesn't affect a lot of people immediately, but you will see full-fledged litigation, and it will go through the entire gamut of the case rather than having a temporary restraining order, I think, because there's no immediate harm done to a majority of cases. But yeah, we are already seeing groups looking for plaintiffs to file this litigation. So yes, you will definitely see that it will be litigated in court, and the administration is in fact expecting that.
All right. We'll take the next one. This is from Umakant Patel. I lived in the US on an H-1B from 2015 to 2021 and have 5 months remaining on my original 6 years cap. No I-145. If the new employer files a petition to recapture this time or extend beyond it, will a new 100K fee apply to me?
Again, you also are cap exempt, just as Anand and Kayur. And so the same rules apply as it stands now and as we interpret it. Anyone who files a new H1 and who is outside the country will be subject to the 100K fee unless they carve out an exception, which they have not as of now. So, or it's not clear that they have. So we're waiting for further instructions. But as of now, it looks like that you would have to pay the 100K fee.
Okay. Next question is from Raghu S. Petition filing outside the USA as a new employment brackets H-1B transfer with an approved I-140 exempt from the 100K fee?
Again, you are filing outside the US, so it is really not a transfer. It is considered to be new employment. It's only a transfer if you're in the country. But I understand, again, you're cap exempt, just as the other folks were. But so far, there is no, it doesn't seem that uh, cap exempt cases are exempt from the 100K fees, since you are filing under new petition and also you're outside the country. So that's who it was meant to address, people who are outside the country. Though they've carved out an exception for people who are temporarily outside the country and are only visiting, and for people who already have their H-1B approved or who have already filed their H-1B, even though they are outside the country, they are exempt. But people who have not yet filed a H1 and who are outside the country, they are not exempt from the 100K fee. So let's wait and see whether they carve out that exception for cap exempt cases as well.
All right. We'll go to the next one from RK. Uh, how is the current H-1B lottery legal when the statute state H-1B should be issued based on the order the application is received? When currently, if someone submits the petition on the last day, can get selected over someone, so submit into the lottery. How is that first come first serve?
So basically, in this instance, everybody is filing at the same time, right? This is what they're going to say. So that's what I said. Litigation will be based on the Immigration and Nationality Act, which says that the person, whoever files earlier, gets selected, gets priority in the lottery. But what happens is, as soon as the date opens up, which is April 1st, everybody files on that date. And the number of people filing on that date has historically been beyond the number of people that can actually file. So because of that, they introduced a lottery system so that it can be randomized, so that there is no um, advantage or disadvantage to anyone who is filing on that date. So here the presumption is everybody is filing on the same date. Do we do a randomized lottery, or do we do a lottery based on the salary? They're already giving some benefits to master's cap people, right? So then why can't they give a benefit to people who have higher salaries, right? So that's what's going to be argued by the administration in court, and we have to see how it plays out.
Okay. Moving to the next one from Jitendra Ronia. Um, come on F1 in May 2024, 8 months campus study plus 7 months CPT, H-1B approval likely soon, planning Nepal trip in October for stamping. Will quick F1 to H-1B shift within 15 months be a question of intent?
It shouldn't be, but you have to explain uh, clearly what happened, that you got the job offer after you started the F1 and you decided to file under the cap and change to a H1. So you have to explain the circumstances, and you cannot show that you always had the intent of being on a H1 or working, and you simply came to the US on an F1 to overcome, and to be able to work faster, or sooner, because on a H1 you can't work immediately because you have to wait for the cap. So you have to, that question might come up, and you have to have a response ready as to how the intent developed, was not there at the time that you entered, but developed maybe after you came to the US because you got a job after.
All right. Next question is from RK. Wouldn't the new proposed lottery system be the same idea as the Masters Cap, where US Masters Cap gets two chances to be selected compared to the persons only in the regular cap?
Right, that's what I just mentioned, RK. Yeah, so that was a good question. Uh, so yes, the master's cap has a separate quota. That's the only difference, right? So they get a chance in the 20,000 separate quota, and then they get a chance in the regular quota. So that way, it's a slightly different because they're getting first put into the 20,000, and then they're getting put into the 65,000, right? So that's the difference, I think. Here, everyone is getting put into the regular um, cap. I guess masters holders will still get put into both, but everybody else who's level 4, for example, will get 4 chances. So we'll get in, if they're also masters holders, then they'll get an entry into the masters, and then they'll get entries into the regular. So that's how it's going to work.
All right, good question. Next one is from Sham. And again, just before I go any further, a gentle reminder, we have 7 minutes still for today's session. We will try to answer as many questions as we can. We are also giving away an early bird complimentary session directly with Prashanti. So if any of you are interested in applying for that early bird complimentary session, drop in your email either in the chat window or directly to Prashanti on any of the socials, and we will be happy to reach out to you. Also, as you can see, many of these questions are coming in from multiple different channels, whether it is YouTube or Facebook or directly from StreamYard. So feel free to type in your question. We still have a few minutes to answer. So next, quickly moving on to the next one from Sham. Um, I think we already answered this one. Uh, Safe to travel for stamping.
I think we already answered
We
it.
have already covered that. Okay. I think we've already covered this. I'll go
I
to the
guess,
next
I
one.
mean, maybe then Sham's maybe next question is whether um, he's subject to the proclamation, though he doesn't ask that specifically, but I'm thinking maybe that's what's on his
Okay.
mind. And you should not be subject to the proclamation because, first of all, it was a change of status, and secondly, it doesn't apply to H1s that were filed before the publication, the signature of the proclamation.
Thank you. I'll go to Ajay Mallavarapu. Will a new 100K fee apply to H-1B 1 Chile, new cases, and first-time travel? Additionally, we would appreciate clarification on the payment process. Should this fee be paid at the time of visa stamping or upon entry into the United States?
All good questions. I don't think it applies to H1B1. They haven't said so. Um, Actually, you know what? I did see something with reference to H1B1 as well. And I can get back to you on that after reconfirming. I don't want to answer and be incorrect about it. So let me get back to you on that, Ajay, with reference to H1B1. I did see something in the proclamation or following that in other documents with reference to H1B1. And I don't know whether it was an exception or they said that it will apply to H1B1. So let me go back and refresh my memory on that. But with reference to, uh, yeah, additionally, but we appreciate, yeah, with reference to payment processing, they have mentioned that in the proclamation, and they said that this will be collected by the Department of State or it will be collected by CBP. They did say that. And they are going to be putting in sending in further instructions as to how it will be collected. Most probably, since they're collecting everything by ACH payment now, they most probably will collect it through, a bank transfer or a wire transfer. And Ajay, please feel free to put in your email address into the text and I will email you back with reference to Chile and Singapore.
Great. Thank you, Prashanti. Next up, we have RK again. If you have to move to live in another state at the end of October, what will happen to your I-485 biometric appointment? Would you have to travel back to the previous state that you filed the I-485?
Okay, good. Some I-485 questions. So if you move out of state, please remember you have to file an AR-11. And also you have to notify USCIS directly by calling them or chatting with Emma. Or if you have an online filing, then do it online. So AR-11 is anyway online. But oftentimes USCIS will not make note of the fact that you moved and a USCIS mail is not forwarded. I would really urge you to speak to the or stay in contact with whoever is buying or renting your apartment and try to get the biometrics that way. Biometrics, if you've used an attorney, will also come to your attorney. And also you'll get a notification, I suppose, through USCIS that biometrics have been sent. So this is some ways of ensuring that you don't miss your biometrics. Because if you do miss them, then your 485 gets denied. So it's important not to.
All right. I guess that's a continuation. From RK, going to file the AR-11 online, but knows the system isn't always up to date.
Yes. Yeah, we answered that. We covered it.
Okay. All right. Next up, we have Ann Chan. Will the wage level based lottery be implemented starting in 2026 March lottery?
Yes, that is the intent. That's what they intend to do. That's why they've published the regulation and they're going through comment period. And any litigation that will be filed before that. So yes, we are waiting to see how that unfolds.
All right. We have a follow-up question from Anand Makate. Follow-up question on my previous question. If I never traveled in my first stamping, is my transfer to new employer from India treated as new petition or extended/renewal?
It doesn't matter whether you traveled or did. I mean, it's the fact of the matter is that you're outside the country. If you're outside the country, it's always a new petition. Whether you traveled or you didn't, doesn't matter. It's always a new petition because you cannot file an extension, renewal, or transfer unless you are physically in the country. So it's considered to be a new petition.
Great. And finally, there is one question that I can answer for a change, Prashanti. Will there be a recording for this webinar? Yes, there will be a recording for the webinar, and we will be putting up on socials, including YouTube. So, and for others listening in, if you haven't subscribed to any of our socials, we highly encourage you to subscribe for latest information, and we post content pretty much on a daily basis. YouTube would be a great platform, so are others as well. So, and we will be sharing this recording on YouTube, and you can subscribe to us. I know, Prashanti, we are above time here. We are a minute over. Any final questions from any of you listening in? Please feel free to type in. We will keep the chat window open for another minute. I will quickly go back to the final slide here as well. I think we are missing Prashanti's email. So any of you trying to reach out to us, there are multiple ways to do so. You can drop in your query on any of the socials we are on, or go to our website and fill up a contact us form there. Prashanti, we do have a couple of questions. I'll quickly take that for you, if that's okay. This is from our YouTube channel. Sai R is asking, currently I'm in the USA and changed the status to B1/B2 due to the project completion with an I-94 expired. with an approved I-140. If I transfer to a new employer, brackets COS, to H-1B, should I leave the country for visa stamping, brackets consular processing, or leave the USA and apply from outside?
I would suggest that you file a change of status and not leave the country, because if um, again, we don't know what will happen with reference to stampings, right? uh, Stamping extensions or new stampings, because you are filing a H1 after the proclamation, right? So change of status applications within the country are fine, but again, we don't know what they're going to do with reference to people who apply for visa stampings on H1s that have been approved after the proclamation. So I would suggest strongly that you file, of course, file for a change of status, and don't leave the country for visa stamping until we hear more about who's affected by the proclamation and who's not.
All right. On that note, we can wrap up today's session. Prashanti, any final thoughts, remarks?
Two things. Number one, for with reference to the H-1B proclamation, please do file that extension, amendment, transfer, whatever you need to do. Please file it within a month, because a lot of things are rapidly changing, and you want to make sure that you file your H1 while the laws are as they are. Prevailing wages might increase. We don't know to what extent. Everything is in a state of flux. So if you're on a H1 and if you want to make any changes, please do that now before any new regulations come out. With reference to those whose visa numbers are available for the October Visa Bulletin, please file your 485 ASAP. And I've already given you instructions on getting your medicals done. Please do that immediately in September itself, so that you're ready to file in October. And also, I see that Ajay has sent his email. So, Vishal, if you can just send me that email address, I will respond to that question that he had from about H1B B1 from Chile.
Certainly. All right. Well, I would like to thank you, Prashanti, for uh, arranging this very important and urgent webinar. For everyone listening in, we understand the criticality of the situation here. So we are here to help you. If you have any further questions, concerns, or need assistance, you can feel free to reach out to us either through our website or through any of the socials that we are available on. On that note, we would wrap up today's.
Vishal, I just wanted to point out that we also have an Ask Immigration session, Ask Prashanti session, where I answer all your questions. So if you put your question on YouTube, if you've forgotten to do it now, or you have a friend who has a question and wasn't able to attend, please put your questions on our social media platforms or on our webinar, and I'll answer it during our Ask Prashanti series. And also, a reminder that I do an Immigration Friday series every week. Every Friday, we have a new episode, so please make sure you watch it, like, subscribe, so that more people will be able to view that information. Thank you.
Great. Thank you so very much, everyone. And thank you, Prashanti. We look forward to seeing you in the next one.